Hello, everyone, and welcome to today's Integrating Doctrine and Diversity Speaker Series event. My name is Greg Bowman. I have the honor and the privilege to serve as the Dean at Roger Williams University School of Law. I'm going to turn things over momentarily to my faculty colleague, Nicole Jaslewski, who is our Assistant Dean for Academic Innovation. But I want to start us off today by reading our law school's land and labor acknowledgement. So as we begin our program, I want to take this moment to reflect on the lands on which we reside. We are coming here from many places, and we want to acknowledge the ancestral homelands and traditional territories of indigenous and native peoples who have been here since time immemorial, and to recognize that we must continue to build our solidarity and kinship with native peoples across the Americas and across the globe. Roger Williams University School of Law is located in Bristol, Rhode Island, and so we acknowledge and we honor the Narragansett and Pokanoket people, as well as Somes, the original name of the land on which our campus resides. We also acknowledge that this country would not exist if not for the free enslaved labor of Black people. And we recognize that the town of Bristol and the very land on which our campus sits have benefited significantly from the trade of enslaved people from Africa. The economy of New England, of Rhode Island, and more specifically of Bristol, was built from wealth generated through the triangle trade of human lives. During this time of ongoing national reckoning with our history of slavery and the disparate treatment of Black people, we honor the legacy of the African diaspora and the Black lives, knowledge, and skills stolen due to violence and white supremacy. As we gather here today, the movement for justice and liberation continues to build in our country, and yet many are still being met with violence and even being killed, while other people in our country actively work to stand in the way of progress. As upholders of justice, our hope is to become agents of change for members of our society who have been met with violence, physical, mental, emotional, through our privilege. And as upholders of justice, we believe that our students who soon will be practitioners of law can be and already are agents of change as well. Thank you again for being here. I look forward to today's program. Nicole, you have the helm.
Thank you so much, Craig. Good afternoon to you, or good morning to some of you in distant time zones. I'm Nicole, and I was thinking about how we should get started today. And I saw on social media my friend Liz, also known as the internet personality Cosbrarian, posted a video the other day that said, "Every single thing I do these days feels like a pantomime of normalcy." And that is a pretty good way of saying it, in my opinion. Here, we're offering another integrating doctorate in diversity, and I'm really excited to be here, and I'm excited about the conversation. But I have this excitement while I also have some serious concerns about the rule of law, the boundaries of academic freedom, and the mental health of so many lawyers and law professors and law staff and law students and others who may be struggling at this time given the national political landscape. So please know I'm happy to be here today, but I'm also holding so many of you in my heart. I don't want to shy away from discussing difficult topics, but I also don't want to fail to acknowledge the context and weight of all that is happening. With that being said, let's get down to business. The theme of today's webinar is executive power in the classroom, addressing Project 2025 and executive orders in the law school curriculum. And our guests today are doing so in a variety of classes in a variety of law schools. I'm going to start today with Allie. Allie Call is an assistant professor at CUNY Law, where she teaches admin law and federal courts. Allie, can you start us off today and share a bit about how you're finding ways to discuss executive orders and Project 2025 in your classes?
Yes, absolutely. Well, first of all, I want to thank you, Nicole, and everyone here for organizing and participating in this important conversation. I'm really happy to be a part of it and looking forward to learning from you all myself as well. As Nicole mentioned, I teach federal courts and administrative law. So one of the challenges for me is not so much how to figure out whether and how these executive orders and what's happening in the world around us relates to my classes, but more honestly how to filter and make sure that we're able to stay rooted in what it is that we're here to learn, while also not ignoring what's happening in the world around us and incorporating those events where they are helpful to our learning and helpful to reinforcing for law students why they are here in law school and the power of the law degree that they're going to get in the legal education they're currently going through. So, for example, I've been teaching administrative law for a couple of years now, and I always start in the first week with a class called Constitutional Foundations. And we learn in that class that federal agencies get their power from Congress, and that Congress is the body that defines the scope of that power, and that the executive branch is there just to enforce the law and to take care that those laws are faithfully executed. And of course, from the beginning of this semester, we've seen an unprecedented, approach from this administration to assert control over federal agencies. And, just to take the Department of Education as an example, there's a federal statute that directs the Department of Education to carry on certain activities. And instead of seeing the Department of Education move forward with that, we are seeing executive orders requesting the Department of Education wind itself down and figure out the minimal extent to which it can carry on activity under its statutory mandate. So it's impossible for me to teach that class without acknowledging that what my students are reading in the news every day is contradicting some of the case law we're reading, which, to be fair, is sometimes from 1928 and not as relevant to what's happening today. At the same time, I think everybody is on information overload. People, on my students, on the one hand, they want to use the classroom as a way to understand what's happening around them, but it's also a challenge to keep moving their learning forward if we are departing from the planned syllabus every day to address whatever's in the news cycle. So one thing I've done is just frankly be candid about that in the classroom and share with the students that challenge that I'm facing, and that if there are days where we're reading old cases and we're not talking about what's happening, it's not because I don't see it and acknowledge it or see the relevance, but it's because we need a foundation of the doctrine before we can tackle these novel questions that are coming up every day. And I've also invited my students to email me, to have an open door with them, that if they're seeing something in the news, whether it's related to administrative law or federal courts or not, that they want to better understand and they would like to use the classroom to, learn about how to contextualize what's happening, that I always want them to feel free to email me about that. And then that I will make a decision depending on what we've got in the syllabus for the day and what the issue is, whether or not that's something that we can work into the classroom. Maybe it's not that day. Maybe I say this is a better fit for a few weeks from now when we return to this topic. And sometimes I've said, this is really important and I want to help you understand this, but we have too much already to cover and it's not something that's conducive to everybody's learning on this topic today, but let's meet in office hours, right? So I've diverted sometimes those conversations to one-on-one opportunities to help students process and understand whatever it is that they might care about if it's not something I'm able to do successfully for the full classroom. In federal courts, it's been an opportunity to address the way the federal judiciary is acting in its constitutional role to issue preliminary injunctions and act as, an arbiter of what is happening with some of these executive orders. And I think if done selectively and well, these executive orders can really provide good learning ground. And so just one example I'll give on that is that the executive order about birthright citizenship came down just about a week or two before we were covering the doctrine of standing in federal courts. And so we read the traditional cases. We covered, Lujan and all of the elements of standing in the doctrine. But then toward the end of class, we were able to look at the executive order, and I could ask the students if this is an executive order that you have legal concerns with, or you are opposed to in some way, could you challenge it, right? And maybe not, depending on the student's background and identity. But, if not, if you're not somebody who's personally injured by this executive order, who could, right? Who are the parties that might be able to challenge this in court? And then we could pull up the actual lawsuits that were being filed and look at who the plaintiffs were and kind of understand with a new framework why the standing doctrine exists, what purposes it serves, and then what types of individuals or parties are able to file suit in federal court to address some of these executive orders. So I think that was one successful example of where something happening in the news did fit in really well into what we were learning. And I think it helped the students care a little bit more about what can sometimes be a dry doctrine and see the real world implications of it.
That's great. It also sounds like a lot of work for the professor. I remember the first semester we taught our race and the foundations of American law class as an elective. It was the spring and it was to start on January 9th, which was 3 days after January 6th. And what we, did from the beginning was build a few minutes into the beginning of the class to allow people to sort of respond to what was going on in the real world at that moment. But either way requires you to make decisions about what are you going to do with precious class time and how are you going to handle people's sort of emotions, because it's not this like neutral thing that's happening. But can you share a little bit about how your students are receiving this instruction? Has this brought up much scholarly discussion? Have you gotten feedback from students about how it's going?
Yeah, so I think, the way that you started this conversation, I thought was a really good parallel framing for the way I've tried to approach this with students from their perspective, which is, we don't want to shy away from addressing these difficult topics. And at the same time, it's really important to acknowledge the weight of what's happening. So with the birthright citizenship order, for example, one of the plaintiffs that brought suit to challenge that order it was an anonymous, she proceeded under a pseudonym, but she was a woman who was expecting. Her baby was due in 2 months. She lives in Massachusetts and she has legal status in the United States through temporary protected status, but the baby's father is not a US citizen or a lawful permanent resident. And so she was bringing this action on her behalf and also on behalf of her unborn child. Now, from a standing perspective, it's a great example, right? What does the unborn child's interest in this case, and what's the injury to both her and to the unborn child? But the reality of that is really upsetting and tragic. And so I think being able to take some time in the classroom to not just go through the doctrine, but also to acknowledge and allow students to share, how they're feeling about that and what these cases bring up on a human level is really important. And for me to also contextualize and say, I'm not bringing this example in to do some cold legal analysis about something that's very human, but to say, these are the implications of this doctrine, right? This is important. And it is and I think the feedback I've gotten is I think it helps students feel a little bit more that the classroom learning we're doing right now is relevant, because I think it can be hard for some of them to feel like we're sitting here in this room away from what's happening. And so I think if done kind of with care, bringing the current events into the classroom can help validate the importance of the book learning and the studying that we're doing at a time where I certainly felt in the beginning of the semester that was challenging for people to kind of focus and get into, reading an old case from 1928 when there's so many important things happening around them. So I think connecting those dots and also just acknowledging we can't necessarily grapple with it every single moment. And so sometimes I think what students need is a break, and making sure we have that built in as well is really important too.
I think you brought up a good point, which has kind of been a theme through a lot of these integrating doctrine and diversity conversations, which is the students come to law school because they want to make change or see change or be change. And then we put them in federal courts and we have them read cases from the 1920s while, there is a perception among some students that like the democracy is falling apart around us. Whether that's true or not, there is this sort of heightened perception of this among some of our students. And how do you know, address this is relevant and interesting and matters. Maybe we don't need to present it in the sky is falling approach, but it is relevant and interesting and matters. And so thank you for sharing that. I think that's really helpful for people in the audience to hear, I hope. My next question is for Tanya. Um, we have so many of our audience members who are librarians, so I'm so excited you joined us. Tanya is a research and instructional services librarian at UConn Law. She teaches courses including advanced legal research, research for social justice, and diversity and inclusion in the legal profession. Tanya, can you please share how you're finding ways to discuss executive orders and Project 2025 in your classes? Do you have any exercises you care to talk about or share with us to show how you're teaching about these matters?
Sure. First, thank you so much for inviting me to be here. I'm really excited. I have been to a lot of these Integrating Doctrine and Diversity webinars, and I've always found them super interesting and helpful. So I'm very excited to do this. So this semester, I am teaching a course called Diversity and Inclusion in the Legal Profession. And the first anti-DEI executive order came down literally the day before my class started. So basically, my entire class has become a discussion of what's going on in the world and what the administration is doing and how that's affecting the legal profession, how that's affecting all of the diversity and inclusion initiatives that have or have not happened in different ways in different places. So I thought it would be helpful to sort of split this into two sort of separate parts. I have the two main goals in this class. And the first of those is that I want my students to understand the actual problem and the scope of the problem in the profession. So both on a structural level, but also on a personal level, and how diversity inclusion, or the lack thereof, affects people individually in their professional lives. So on that, to that purpose, we have readings and discussion, and we also have a lot of guest speakers come into class. And talk about their experiences personally in their careers, but also what their organizations are doing. And in that context, almost all of the students have asked very hard questions of the speakers about what are you doing with these executive orders and how do you feel about this and what are your organizations doing. And recently we had a couple of partners from law firms come in, and with all of the executive orders that are and the letters from various places that are targeting law firms, the students are asking these very difficult questions. What would you do if your law firm were targeted? And what would you do if you didn't agree with what your firm was doing? And why aren't law firms banding together to fight these things? Why are so many of them really bowing down to things that maybe they shouldn't be? And that's led to a really robust discussion among what is the role of a law firm and what can we do? What power do associates have in law firms, since these students are soon to be, many of them at least, are going to be associates in the near future? What do management decisions do in this context? What impact do decisions made by partners for business reasons usually have on other folks who work at the law firm, who may be people of color, who may be queer or trans? What is that doing? And it's been a really great discussion. But that's all sort of somewhat abstract in many ways. So the second goal that I have for my class is to not just wallow in the depressing statistics, but rather to really try to come up with solutions and really think about ways to improve the profession and ways to be more inclusive. So what I've done generally for the class is I've written a few different scenarios, hypotheticals, for the students to work on and think about in small groups, and then they present recommendations to the class, and we have some discussion about it. So I've incorporated some specifics about a few of the executive orders into some of these scenarios. And I think one of them is already posted in the chat. So if anybody wants to take a look at that. I think this is, at least in my opinion, this is a good way to approach it because many of these orders are really confusing and vague, and I don't know what to do with them. So how am I going to expect my students to understand what they're talking about? So instead, I give them a really specific scenario with some specific questions so they can think about how does this apply to a particular situation? What should we do here? How can we hypothetically as an organization or as a lawyer, how can we still accomplish these goals? And it makes it feel, I think, more practical and more manageable. So one of the scenarios, and this is the one that was posted in the chat, is about a legal services organization that is reliant on federal funding. And they also have a specific program that to assist transgender, non-binary, and intersex young people with legal issues. So the big questions for these students are, first, how can this organization improve their hiring practices to be more inclusive, being mindful of the dangers of potentially losing federal funding? And secondly, how can they continue to offer this specialized legal service and maintain a trans-affirming workplace for their employees? So this is an elective class, so my students all think that diversity and inclusion is really important, which is great, but they have a lot of disagreements about how to accomplish these goals and what to do in different circumstances. So for this particular scenario, there were quite a few students who were very like, we have to go all in. We can't change our language. We have to really double down on this because it's so important. And who cares if we lose our funding? This is too important to care about that. But then on the other side, we have students who are saying, no, no, no. We are a legal services organization. Our goal here, our job is to provide representation for people. We can't do that if we don't have funding. We need to do something differently here. We need to make sure that we can continue to service people because this is not, people who are facing eviction don't care what our job descriptions say. They just want our help and they need our help. So how do we go about doing that? And it was really fascinating to see the different students and their opinions on it. I actually had one student who does not participate often, so I was very excited to see this particular student speaking up. And they actually rewrote the job description, which was not required, but they just felt so strongly about this particular thing. And they said, no, here, look, we can do this. Look, even if we change our language, we can still be doing these things. And it was really fantastic. Because this is what I was hoping they would do with this, is to engage in how do we practically manage this? I think it's important because we have to live and function within the world that has been created now. Whether we like it or not, whatever we think about the legality or constitutionality of what's going on, lawyers and organizations still have to deal with this. They still have to function on a daily basis and do their day-to-day jobs. So I think it's important for my students, at least, to be considering how do we maintain our commitment to diversity and inclusion in the face of all of this? How do we survive and how do we thrive in these circumstances? So I'm happy to talk more if anybody wants to talk more about that.
I have a follow-up question. So I also would highlight that bar associations, in particular, Rhode Island is a unified bar, are really struggling with some of this. But I wanted to go back to your first point where you said, oh, it's not all doom and gloom. How are you and your students and your colleagues sort of dealing with at least the first part, which is doom and gloom?
That's an excellent question. I actually have a lot of conversations with students about coping skills and how to really take care of yourself when you're thinking about this so often. I think it's a very personal journey, but I think that the thing that I found helps the most, and I have learned this through years of therapy myself, is that if you take one action or take one step, even if it's a really tiny action or step, it can really help combat that feeling of helplessness, which I think underlies a lot of these doom and gloom, as you put it, is really just it seems so overwhelming and so big. So how can anything I do matter? And I think it's important, and I talk to my students about this too, about recognizing that even little things matter. If you help one person, you have changed that person's life. And that's not something that they often consider, because most of law school is on this larger level. We learn important things in law school, federal courts and administrative law, like Allie was saying. But like individually, though, like our profession is about advocating for an individual client most of the time. And changing one person's life matters. And I think that sometimes helps.
Thanks for sharing that. I've been working on advocacy for the freedom to read in Rhode Island, and I had this really touching moment last week where I was testifying in front of a Rhode Island House committee, and my research assistant came, and I felt like, well, this is the gift I can give, which is that we all could just do the one thing, and it doesn't have to be the same thing. And I'm not expecting everyone to be as motivated about book censorship as I am, although you should be, but I'm not expecting it. Um, and it did feel like I gave that student a gift of like, here's this one thing we can do, and you were able to do it and see it, and that matters. I also would say I watch a lot of really bad reality TV, which is my lifelong coping mechanism for getting through almost anything. Um, Thank you so much, Tanya. I'm gonna turn the conversation to Dr. Taino Palermo, who is an adjunct professor at RW Law, but also an attorney, and co-founded the Center for Indigenous Peoples' Rights, the East Coast first and only pro bono law and policy center focused on the rights of Indigenous peoples. Dr. Palermo's areas of specialty include community and economic development, American Indian and international Indigenous peoples' rights, and education policy and practice reform. We're going to drop a link in the chat to the Center for Indigenous Peoples' Rights, as well as information about their annual gathering happening this weekend, which is also available virtually, being live streamed. And my description of Ty could go on and on and on because he wears so many hats. But I did want to ask, from the perspective of a teacher, it is not just about the creation of new executive orders, but about the rolling back of Biden executive orders that can be really making a difference. Can you talk a bit about what class you're teaching this semester and how you have chosen to present Project 2025 and or Trump executive order behavior, and how you see this impacting your students?
Sure. Thank you again for the opportunity to join this panel. As Ali and Tanya said, it's timely, it's important. And yeah, so I teach tribal courts, governments and law this semester, which is a scaffold to federal Indian law, which I teach in the fall. And I'm also a product of Dr. Diamond, so I'm also interested in hearing his responses here because I really took to him as a professor when I was a law student during COVID. And so during COVID, we saw for the first time, and I practice education law as well. And so for the first time, we saw a real stress test of our legal system, of our rights, what it means to have our rights tested. So it was interesting to be in law school around that time, and dealing with everything we were dealing with around vaccines and mandates and things like that. And so, but I'm also an older person and not a traditional quote unquote age law student when I was in law school. So I had, a history of teaching, and so by the time I started teaching at the law school, I wasn't new to being in these spaces and having to kind of create space to let students kind of process things. And so that was always kind of my pedagogical approach, was to kind of just really allow students to understand we're all learning from each other and everybody has value to bring to the class. So that's kind of my general MO. And after, everything that kind of has been an avalanche of news since January, I knew it was absolutely critical to kind of just stop and create some space. And little did I know doing so would have has I mean, we spent probably, I thought would have been 5-10 minutes of kind of trepidation around engaging in this conversation to like verbal vomits of like freak out. And I knew then it was like, okay, all right, let me because predominantly the class is younger people. I may have a couple who are older students. So this is, you know, for all intents and purposes, they're kind of real first holy crap moment of like what's happening in my nation. Now, you know, I'm Puerto Rican. I come from Puerto Rican activists, family members. I come from a history of advocates and community organizers. And so, you know, knowing that our government isn't always in our best interests is not a new concept to me and the history of my people. And then, you know, being educated and an educator around federal Indian law, indigenous law and policy, you just know history tells you can never feel comfortable, stable in the world of federal Indian law and policy. It really doesn't matter who's in office uh, or who, you know, or what the political leaning is of the Supreme Court. The two are never in alignment in favor of all things, you know, Native American or American Indian or indigenous to U.S. territories. So in the world of federal Indian law, you know, we reiterate the theme of like the volatility of what it means to be subject to federal Indian law. And so, you know, from one decade to the next, things change. From 1 year to the next year. So undoing Biden era, you know, initiatives is not new in the world of federal Indian law. And so what I've been trying to do is kind of tell folks like, you know, this is not to be undersold. This is a serious stress test of our Constitution. That aside, you know, you have to keep a couple of things in mind. One is that these are predominantly unserious people who have control of serious things. And so, although that's scary, it's also we see the fumbling idiocracy of, you know, firing people and having to rehire people and not knowing the scope of what you're doing when you're you know, trying to do surgery with a chainsaw instead of a scalpel. And so these kinds of things are where the law comes in to challenge, slow things down, stop things, prevent things. And so it's important that we have more attorneys. So when I was in law school, it was COVID, but as Nicole mentioned, it was the summer of George Floyd and the racial reckoning and this appetite for civil rights and civil justice and equity. And so the sentiment then was like, we need more lawyers to help protect people's civil rights. And I would argue now we need more lawyers and more advocates around this separation of powers, understanding the checks and balances, holding political people accountable. And so what I've been trying to do in class is really kind of connect these kind of crazy things with things in the past. So the executive order to end birthright citizenship is a direct parallel to the Supreme Court case Elk versus Wilkins, which I know Allie mentioned this. It was in 1884, this case, but it's completely relevant in 2025. Elk versus Wilkins was a Supreme Court case that denied citizenship to Native Americans who like defected from their tribe and no longer under the jurisdiction of their tribe, and lived amongst white people. But they were not considered U.S. citizens under the 14th Amendment until 1924 with the Native American Citizens Act. So this isn't new to Indians. Again, on theme. This is not new. And so, you know, we saw things like a lot of us, a good portion of my students are from the Midwest and Southwest. So they interface in their state governments with tribal communities all the time, Arizona and New Mexico in particular. And so they see these situations where tribal communities are putting out notices to members to make sure you have your tribal ID card so you don't get swept up by ICE. Because out there's no distinguishing between Native American and Mexican or Latino appearing. And so, then we kind of take it a little level deeper and say, all right, so now can we all at least agree that we're dealing with colorism policies here? Because it's not about legal status, it's about you look like you're illegal. And now we have this kind of unfortunate convergence with the Native American community also living in a predominantly Latino community that also is, stereotypically, people who are here undocumented. And so we see these kinds of things around the revoking of the executive order for federal funding for tribes around schools and Indian health services. And we draw a parallel right back to all of these federal policies that have flip-flopped back and forth depending on who's in office and not. And so sometimes, not all the time, because people have different levels of freak out, but for the most part, I've been able to kind of mitigate at least from what I could see in the 90 minutes in our class of the freak out, such that we can kind of see these parallels. Oh, okay, so this isn't the first time it's been crazy like this. It is the first time we've seen certain elements, but this isn't really the first time we've seen these kinds of things. So I create the space, and I also try to draw parallels to try and calm the fear that this isn't the first time we've seen actions like this.
Well, one of the things I want to sort of amplify from what you just said is the slowing it down, the role of the lawyer to slow it down. That whether you conceive of the things that are happening are illegal or innovative or destructive, the role of the lawyer in processing it and slowing it down and the separation. And I think that makes a lot of sense and is a really helpful frame for this. I'm going to bring Jim Diamond into the conversation. Excuse me. Jim is a visiting lecturer in law at Yale Law School and senior counselor for Indigenous programs at the Yale Center for Environmental Justice, among many, 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 many other things in his career. Jim, I read online about what Ty and Allie are talking about birthright citizenship for Indigenous people in the United States based on the litigation following a Trump executive order. Can you try to slow this down for me, someone who doesn't practice Indian law or immigration law? What does this mean? How are Indigenous people, Indigenous communities reacting to this? And because you have a relationship with a number of academic institutions, how have you seen some of these issues being covered within the classroom or even beyond the classroom?
Yes, well, thank you, Nicole, and I'm very appreciative to be included on this prestigious panel, and happy to be here. Thank you for inviting me. I agree a lot with what Allie said about what's going on, in the classroom. Law students have a lot on their mind, a lot on their plate, and professors are juggling, trying to get through the material and then react to what's going on. Like Dr. Palermo said on citizenship, it's troubling, to say the least. This is a matter for Indigenous people that's settled for 100 years. It was settled with the enactment of the Indian Citizenship Act of 1924. And yet it comes up. And so, like Dr. Palermo said, that you have detention of tribal members based on little other than appearance on the Navajo Nation some 15 tribal members were detained, stopped, and interrogated until they could refute that. But I wanted to talk a little bit about, to answer your question about how this fits into what's going on now with executive orders and what's going on around the country. There's a theory out there. It's a theory that I don't ascribe to. That it's called the unitary executive theory, and the Trump administration is pushing it. It's not the first time it's been pushed. It gives the president broad powers, and I think that's the theory for, if there is a theory for pushing these executive orders. But they don't really apply in Indian country for several reasons. You have over 300, nearly 400 treaties with tribal nations, which treaties negotiated in the 19th century and are still the law of the land. And those treaties give tribes sovereign powers. They create responsibilities for the United States. And those responsibilities can't be shirked with an executive order. Those treaties promise care and a trust responsibility for the United States, and it includes responsibilities for health and welfare, education, etc. So many tribes have gone to court to counter where those executive orders run contrary to treaty power, treaties, and many federal statutes that can't be waived off very easily. There's litigation coming from at least 4 tribes: the Arapaho, Cheyenne, Penobscot, and many others. At Yale, there's discussion in the classroom. I would say more discussion of executive orders and what's coming down outside of the classroom, whether that's bringing in of outside speakers at lunchtime, of which there's 2 a day at Yale Law School, and then what's going on in the clinics, which is profound, the immigration clinic, the environmental clinic, etc. Yale students are involved intricately in various aspects of litigation at various levels. So I think that, when it comes to tribal nations, there really is a separate carve out for the relationship to the United States that goes back to, contact is, more than 200 years old, and can't be waived off easily, will be the subject of litigation, and I think successfully. This unitary theory of executive power, it does exist, and might even have some proponents at Yale. I would say that at Yale Law School, there's a diversity of opinion, differing opinions, and so that's maybe some rationale for caution in the classroom. I would also say this: yesterday, 62 Yale Law School professors sent a letter out to the students, professing our support for the rule of law. Also expressing that we understand that some international students are concerned, fear their status, and so that was yesterday. 62 professors, and I think that that's something that's happening at law schools throughout the country.
Thank you so much, Jim. I'm going to add Jeff to the conversation. Last but certainly not least, Jeff is the Assistant Professor of Law, Joseph H. Goldstein, Faculty Scholar, and Associate Dean for Academic Affairs. And to start with, Jeff, what are you teaching this semester, and how are you choosing to bring Project 2025 and or executive orders into the classroom?
Thanks so much, Nicole, for the question and for the invitation to participate in this conversation. Just want to say that I'm grateful to Roger Williams University School of Law for hosting this, and our very own Penn State Dickinson Law Anti-Racist Development Institute for co-sponsoring. This semester, I'm teaching education law as a seminar course. I'm also co-teaching a first-year required course called Race and Equal Protection of the Law. I'm going to focus for my remarks, though, on education law. There has been a lot that has happened over the last 3 months, and numerous ways in which Project 2025 directly and the executive orders have intersected with our work in that class. In the very first class, I spend time going over the various stakeholders in education law and policy. So we talk about the federal government, the state government, federal and state courts, local educational authorities, and parents, sort of narrowing to the most direct and immediate in a community. And in that class, I detail the various ways that their roles intersect, the authorities of each, and try to capture some of the interplays between them. It's also in that first class that I acknowledged that the dynamics this semester were likely to be fundamentally altered within weeks, because mere weeks later, a new administration was entering Washington, D.C., and there were a lot of, at the time, aspirational goals that are now actually being realized. Like I said, at that point, these were just sort of references of possibilities. As the class is a seminar, students do select a topic to research over the semester. I have a step-by-step process that they have to develop that paper by the end of the semester. To assist them, I provide resources on a course webpage to learn about the hot topics in education law and policy. Just like I did when the Biden administration came to office, I provided links and resources to all of the various campaign remarks, web pages, plans related to education law and policy. Students can then use these as resources to find a path for their research and writing, identify a topic, etc. Unsurprisingly, many of the papers intersect with the goals related to the Trump administration's time in office. They also intersect with ongoing current federal litigation in courts related to these political goals. It's made for a very interesting, that's putting it mildly this semester, an interesting process as students are navigating what is unfolding in real time, the opinions as they come out, their views about the opinions and incorporating them, and the executive orders, political rhetoric, proposed regulations, and more into their paperwork. Last comment I'll make is that the class is organized around legal matters of education and minoritized student identities and needs. That's my decision as a framework for that seminar. We spend weeks in blocks going over issues related to race, language, immigration status, religion, sex and gender, disabilities, while intertwining into those conversations compulsory education, attendance, constitutional rights of teachers and students along the way. It's a lot to fit into 2 credits, as you can imagine, plus students actually present on their research. I share all this because throughout, we've really had to confront week by week the real possibility that what we are studying now literally may not be the reality by the end of that very week. In fact, I will never forget teaching in the race and the law section, one class on segregation and Brown. The next class period, we're talking about affirmative action. And the very next week, the Dear Colleague letter comes out with a very different interpretation of the SFFA case than my class had come up with. And so as part of all this, we've been referencing the changes as we go along, but I'm actually changing the end of the semester. I've removed some of the topics. So in a couple of weeks, instead of what I had planned, what was stated on the syllabus, we're going to spend a full 2-hour class session just focused on looking at executive orders, Project 2025, and cases related to the topics that we covered in a different way earlier in this semester. And so it's been a challenge, exciting on some level to kind of be very contemporary and current. Although I will admit, I wish we were not quite as contemporary and current in us trying to follow along. The beauty of the class as I designed it is that it is an open source class, so adjustments can be made as needed. But it's been a lot to process and a lot to go through. And I do want to acknowledge here that while this class, in this class, there's been very obvious and highly publicized ways in which the administration is seeking to change, deconstruct the federal government's role in education. I know that this experience is one that is being faced across the curriculum, right? Our administrative law colleagues shared some. Con law has been overturned year after year, it seems, of late with the new composition of the Supreme Court. And that a course like the one I'm navigating right now and the race and equal protection law class, in some states and at some universities, there are intentional efforts to even silence content like this through fear.
Thanks for, I'm not suggesting that you're complaining, but I do want to do a callback to something Allie said. This is a lot of work. And I think sometimes as professors, we don't give ourselves the grace to know that not only are we dealing with some of these issues sort of on a personal level based on our own identity, our politics, how we see ourselves, who we are, but then we're also sort of putting on the sort of teacher face and having to change our curriculum or choosing to change our curriculum and engage in these conversations in class and do it in a really genuine, meaningful way. And that is not easy work. So I just want to say thanks to everybody here and thanks to you at home who are doing this too. It's also really messy. As someone who teaches in a race and the law class, things can go left or right, depending on how you think about it, very quickly. And you're just like, look, I just want to get through what is a new class prep because I chose to go in a different direction. And then all of a sudden something is popping off. So I think you brought up a good point, which is we need to give ourselves a lot of grace because this is new. And while it might be described as interesting or exciting, like you said, it's also can be terrifying and problematic, and depending on what institution we are at, can sort of get us in trouble outside the classroom. So thanks for those comments, Jeff. And I'm just going to stick with you because your research interests are exploring topics at the intersection of LGBTQ plus inequality and family law, education law, and international human rights. Can you talk about the way in which some of specifically the anti-trans policies and laws are impacting our law students and our communities?
Yeah, absolutely. So I want to acknowledge first and foremost, continuing thread to what you've shared. This is a very difficult time for me professionally and personally. As much strength, confidence, and stability as I try to provide students in the classroom and outside the classroom, we are also still human. So while articulating the advancements that have been made for the LGBTQ plus community and acknowledging the room for continued improvement, I also have to bring in that sort of balanced perspective of one, this impacting me individually, but two, this is going to impact, the students individually as well. And that balanced approach has become extremely difficult to manage. On some level, it's untenable as of late because past framing and decorum has really gone out the window and shifted to tones and substance that are dehumanizing, demoralizing, and defeating. And while my professional resolve, as I said, remains as strong and committed to the values and goals that I have for the law, it's hard on the personal side to find the strength sometimes. I'm a member of the LGBTQ plus community myself. I have a husband. I have 2 kids. Those are folks that I worry about and I love. And these laws, anti-trans laws and anti-anybody laws, frankly, impact me directly. Anti-trans policies hurt me, my community, my students, and all of our communities and families. I recently spoke at a law review symposium to recognize 10 years of Obergefell, the landmark marriage equality case, where I reminded attendees that our human rights are inherently indivisible, interdependent, and interrelated. And what that means is that an attack on the rights of trans people, a tiny sliver of people attempting to live their lives authentically, is an affront to all of us. And if you don't think your rights are next, you're naive to the realities of now governing our country. These are political strategies to demonize one by one people in this country who carry minoritized identities in ways that frankly seek to strengthen and restore power to white supremacy, a patriarchal society, Christian dominance, and heteronormativity as the expectation. These are the values being advanced by starting with trans people. Trans people have been politicized. And I'll end by saying earlier today, I attended the Anti-Racist Development Institute's Coalition Update, and it was said by a very, very powerful and well-known man with a trans experience, and I don't have his permission to share this quote by name, but he said numerous times, if you aren't scared for your trans friends right now, you have no trans friends. These truly are matters of life and death for all of us right now. Matters that disintegrate democracy and the rule of law. And I encourage everyone to be brave, to be resolute, stand up, speak up, and act up before it's too late for trans folks, and frankly, you and your way of life. That sounded really ominous, but it's true.
It actually kind of punched me in my feels. I've been sick this week, and it's it is very hard when you're sick to not spend the week sitting on your couch just kind of doom scrolling. And so that maybe didn't sound ominous to me, but it kind of made me tear up because, well, for the obvious reasons, I guess, because so many people are personally affected. And I think about how many of those people are on this webinar today, and I think about how many of those people are my students and members of my community. It's hard to keep going, and it's hard to keep going sort of with a pleasant face on. So thank you for your honesty, even when it's clearly difficult, but genuine. I want to turn to Allie. Allie is one of the founders and the CEO of the Purple Method, which we're going to put a link in to learn more about. In a recent blog post, Allie, you stated that, quote, recent executive orders calling on employers to end illegal DEI programs have raised more questions that they have answered. To add to the confusion, President Trump recently took the unprecedented step of firing 2 of the 3 Democratic members of the EEOC, the federal agency tasked with enforcing the nation's workplace equality and anti-discrimination laws. The EEOC now lacks the quorum it needs to issue new rules or to change or revoke existing guidance. Law schools are also places of employment, and many of our students are being trained to be the next generation of business leaders and policy advisors. Can you please share any advice you have about how our schools and our teachers should be handling all of this anti-DEI rhetoric and handling these times of great uncertainty?
Yes, thank you. And I think actually this question goes to some of the questions in the Q&A as well. So I'll try to incorporate those into my response here. So I think this is a great example of where law students can really put to work their new legal analysis tools. Jeff mentioned the holding of students for fair admissions, which is about the use of race in the admissions process, right? And I was at a law review symposium on Friday where we were all discussing the implications of students for fair admissions, and yet that case is now being invoked for much broader ideas, like universities can't teach certain classes, or universities can't run programs on campus that are geared toward promoting diversity and inclusion. And that's, if you read the case, that's not what SFFA held or what it said, right? And yet we're seeing a lot of universities and other institutions sort of pre-comply with the way these cases are being characterized. And so I think for students, it's almost a helpful example. In the workplace context, somebody mentioned Title VII in the Q&A. This is also true, right? Title VII is being invoked to say certain diversity, equity, and inclusion programs are illegal, and yet Title VII is about the fact that you can't make hiring decisions on the basis of a protected characteristic, or firing decisions, or promote somebody, or, you know, dock their pay. And it prevents a hostile work environment, but it's not necessarily saying you can't do diversity training, right? And so I think it's a way for law students to really, you know, look at the law, read Title VII, read SFFA, and then decide for yourself, do you really think that what is being told to you about what these laws say is in line with the text of the statute, or is in line with the holding as you might read that? So I know we're running out of time. There's so much more I could say about that, but I hope that helps answer some of the questions that I also saw in the Q&A.
Thank you so much, Allie. We are running out of time. We have 2 more questions. This next question is to Ty and Jim. What advice do you have to teachers and administrators who are not teaching classes specific to Indian or tribal law, but want to make sure their students are learning about threats to Indigenous lands and communities? And both of you can take a step.
Go ahead, Doctor.
Well, I think that, you know, we've made some progress, but not enough, with, you know, law professors, including Indigenous law and policy, you know, in all classes. So, you know, I think that it requires, you know, a deep introspection. You know, what do we know? What can we do to you know, to educate our students? I think it, you know, for example, when teaching a class in property law, and we teach, you know, the Johnson versus McIntosh case, it's taught, you know, routinely as a property law case, but yet very horrible white supremacist language from that case is not taught. And I think that, you know, top to bottom in law school curriculum, Indigenous law and policy, you know, can be integrated, should be integrated. I'm very proud of the work that I've done introducing that subject in 3 law schools, including Roger Williams. You know, I think it's a challenge to our profession, to law professors everywhere, from constitutional law, you know, to administrative law, to property law, criminal procedure. It's something that, you know, is long overdue.
Yeah, I would just add to that, you know, also what is helpful is to kind of, which, you know, sometimes professors can get caught up in like the generalization of the body of law they're teaching. But I think if you can bring it connected to where your state is, and then, you know, like here in Rhode Island, when Roe versus Wade was overturned, Rhode Island was already ahead of the game by codifying Roe versus Wade and protecting a woman's right to choice. So Rhode Islanders were safe. In that same spirit, when Halan v. Brackeen was on the docket, the Supreme Court, and ICWA, the Indian Child Welfare Act, was in jeopardy, states across the country were sharing resources to pass a state version of ICWA in the event that it got overturned. And so Rhode Island did that same thing here with the Rhode Island ACLU and the Center for Indigenous Peoples' Rights. So, you know, kind of connecting it to, you know, your place and space kind of helps as well to kind of just take it out of the classroom and make it a little bit more real. And then, you know, you give your students avenues for engagement, showing up to the State House, you know, advocating for bills and things like that.
I think a lesson that I have learned from the 2 of you is it's not a lot of work to figure out how Indigenous issues or issues that affect Indigenous communities can fit into every class. It is more work to figure out how they haven't all along. And so like that is the gift that you've given me, which is it's not, I don't need to do a lot of creative thinking to fit something in. I just have to realize what was there all along and maybe, supplement my textbook and reach out for some additional perspectives where maybe I hadn't seen it before. So thank you to the two of you. And I'm going to give the last question to Jeff and Tanya. Although, Jeff, I would ask if you could please not make me cry for the second time during the session. Jeff and Tanya, I want to close with you because you're both very much student facing and student engaged. When is this talk about the current administration too much? I have heard some chatter from students along the lines of, we're here to learn law, not politics, or all this talk of anti-DEI, anti-trans, and anti-immigrant talk is impeding my ability to be able to learn. And I think that is genuine for some students. I do think if every class starts with, what the heck did Trump do today? And let's take the first half an hour, maybe that's too much. But where we're at right now, according to the two of you, being really student-centered, can you share a little bit about how do we as teachers and administrators and staff, how do we achieve a balance between acknowledging what is going on, advocating for ourselves and our communities, but not impeding learning?
Would you like me to go first, Tanya? And then you'll be the finale of the day. Don't make Nicole cry. We've been forewarned. All right. So first I want to say, in terms of thinking about this question, I caution us from using student well-being as an excuse or even perhaps permission to avoid having difficult conversations. While I'm extremely compassionate about the harm some of these efforts have on students, especially those with minoritized and targeted identities, saying less runs a greater risk of harm in that we might be perceived as callous at a time when students need to know that we see and hear them. More than not talking about these matters as they intersect with law, we need to be creating spaces to talk about them. That's what students need most right now, and I've seen that firsthand. International students have expressed fear about threats of ICE coming to campus, visas getting canceled. I've had LGBTQ plus students in my office fearful about having access to HIV-related medicines, transitioning support, and even a place to use the restroom in the future. Students of color are fearful and uncertain about what all these DEIB attacks mean to them and their communities. Not talking to me seems like not an option. In doing so, of course, though, we need to be careful as to the line between politics and law, but the reality is that we're completely in new terrain on this front. There past frameworks of what to expect from our government, democracy, and rule of law simply no longer apply. And in that space, we as academics teaching and learning the next and training the next generation of lawyers need to model a new type of discourse on difficult topics that focus, in my view, on humanity, community, and authenticity. Past artifices of hierarchy, caste, and culture in law schools must bend to meet the needs of our students now and the profession that they are entering at this moment in history. So using the skills and knowledge accumulated through our own professional development, I'm very hopeful that law school staff and faculty, both, all people that work at a law school, have important work that can find ways to balance the challenges of the day and the need for these important conversations and those that are undoubtedly ahead for us.
I think you answered my question. Is there ever too much authenticity and vulnerability? And the answer is clearly, well, there can't possibly be. But Tanya, it's going to be hard to follow up on that. But if you could please not make me cry, that'd be great.
I will do my best. I admit I got a little teary earlier too. So I think that it is so hard to consider the fact that, like, do we even need to have a balance? Because there is so much hatred being spewed at us every day, day after day, in so many different ways, from institutions that I don't think should be based on hatred. And it hurts me personally as a queer person, as a grandchild of Holocaust survivors. Like, I see where this is going, and it hurts. And I think it's important to share that with students and acknowledge that they're also feeling hurt and angry and all of these things. And I think it's the students that are challenging these discussions that need that education the most. Like, this is a moment where we can try to connect with these students and really say, like, look, I understand that you don't see it this way, but here's my personal experience, and here is how what you're saying is affecting me. And I've had a couple of those conversations with students who, lean on the conservative side, and like, they're really good conversations. And I think I've really been able to at least reach a couple of them. And that is where I think we really need to go with this, is to really bring everyone into this conversation and say, like, let's really talk about this. Why do you feel the way you do? Why do I feel the way I feel? And let's really discuss this and have those difficult conversations. So I don't know what else to say about that, really, beyond I think we need to do more of it. I agree. I totally agree with that.
Thank you so much. Thank you all for attending the session. Thank you so much to our speakers. I'm sorry there were so many speakers in so little time. We did the best we could. Just our next session for integrating doctrine and diversity is on April 30th, titled Expanding Doctrinal Dialogue with Foreign and International Current Events Content. And there should be a link being sent to you soon about that. Again, thank you so much, and thank you to us behind the scenes who help us get to this point. Have a really great rest of the day.